From the Oklahoman, I'm Dave Morris. Last week, the U.S. Supreme Court ruled that the state of Oklahoma had wrongly tried a child rapist who was an Indian and whose crime was committed in the boundaries of the Creek Reservation. The decision in the case of Jim C. McGurk was followed by the court overturning convictions in 5 other cases, including those of a death row inmate and a convicted murderer. This week, the 5 tribes, and the Creek Nation is among those tribes, have reached an agreement aimed at clarifying jurisdiction on criminal and civil matters. I'm joined by my colleague, Chris Castile from the Oklahoman. Chris, as always, great to see you. Tell us about this agreement that we heard about today.
David, is an agreement in principle between the 5 tribes, what used to be known as the 5 civilized tribes, which is the Cherokees, Chickasaws, Creeks, Choctaws, and Seminoles, and the state about how to move forward after this really historic Supreme Court decision last week. Basically said the whole way the state has been treating criminal cases involving Indians for the last 100 and some years, 113 years almost, is wrong. State, according to the court, the state never should have been trying these people in state court, never should have been trying Indians for crimes committed on Indian land, which, by the way, they said most of eastern Oklahoma was still Indian land. So it was a huge decision, huge implications, a lot to digest. And there was a lot of concern among the tribes and with the state about the confusion that might be created if the court ruled the way it did, which was to basically upend the criminal justice approach that had been in practice in statehood in 1907. So even before this came down, in the eventuality that it might go the tribe's way, they began working on a framework for an agreement, and they announced that agreement today. They announced that framework today. And it's really interesting in that basically it would try to restore to the state a lot of what it lost in that decision last week. You would have, and it's going to be kind of confusing, I think, for everyone for a while, but you will have, if Congress passes this, if this goes to Congress and is approved by Congress, you would have what would be essentially concurrent jurisdiction over a crime. You mentioned the child rapist who is at the center of this case, Jim C. McGurk. If this is approved by Congress, he actually could be tried by the state again. I mean, if a similar case arose, if Congress were to approve this agreement with a Jim C. McGurk type case, the state could try him, despite this kind of landmark decision from the Supreme Court saying last week that the state never should have tried him in state court, that he should have been tried in federal court because of where his crimes. It's really confusing. I apologize, but so much having to do with Indian law and jurisdiction, and what law applies where, depending on where you're standing at the moment, can be confusing. And it got even more so last week. And now on the civil side, there was a lot of concern going into this case, and then after it was decided, about regulation, about taxation. Am I all of a sudden, you're a private property owner, say in Tulsa, a non-Indian, who's owned a house for 30 years. What's up? Is my house on a reservation now? Can the tribe start taxing me? Their own sales tax, their own income tax, whatever. All of these questions arose in the wake of that decision. So they are also trying to, also trying to address the civil matters, the civil questions that arose out of that. And again, I think mainly trying to hew to the status quo before this decision was announced. Nothing, not disrupt anybody's property rights, not disrupt any oil and gas drilling, not disrupt any contracts that were ongoing, to try to kind of just smooth this out and allay people's concerns that all of a sudden you're living on an Indian reservation that you didn't know you were living on until the Supreme Court told you so.
That was some of the immediate reaction when we heard the Supreme Court's decision last week on various social media channels was, well, immediately this is going to mean X, Y, and Z. Well, perhaps not. And as you mentioned, that's why the state and the tribes are establishing this framework. I remember studying some tribal law back when I was in college, 5 decades ago, and how specific and complicated it could be, because you were talking about the sovereign nations, and that decision last week referenced that. So what are you
And
hearing?
that's a really important point. That's, and it's hard. It's hard for a lot of people to understand that, to understand that these are nations with their own government. The U.S. government, the state government, has to deal with them government to government, and that's what's going on here now with these negotiations with the state. The state government is dealing with these 5 governments whose reservations span much of eastern Oklahoma. Sorry to interrupt.
No, you're exactly right. And I will point people to your article on Oklahoman.com by Chris Castile about this, because as he alluded to just a second ago, you've got Indian, non-Indian, tribal land, non-tribal land. That's just making things really vanilla there. It's way more detailed and complicated to that. But again, you mentioned the framework. So what are you hearing that the state and the tribes are doing to kind of prevent an upheaval in civil and criminal matters?
What they're trying to do, respect each other's, respect what each other had before this decision came down, and enhance it. Maybe allow the state, to continue to operate the way it was operating in many criminal cases, but not to take anything away from the fact that the tribes now, their boundary, that this decision proved what they've always said: our boundaries remain intact. And where this has to go now is Congress. And again, it is really just kind of a framework for an agreement. It's not, I was talking to one of the attorneys today, the Chickasaw attorney, who helped negotiate this, and he said this could be a mere 6 to 8 pages of federal legislation. That's all we need. It's not going to be some law book length statute necessary, but they do need to pass this agreement to kind of restore that status quo that was disrupted by the Supreme Court last week. Like right now, today, as we're speaking, if there were a murder committed in that reservation, those 5 reservations, by an Indian, then the federal government would have to take it. Now that could change back to the way it always was if Congress approves this agreement. There could be tension. There's likely to be tension at times over how all of this plays out. But as the tribes can maintain, and the state to some extent, but the tribes and people like former governors and Congressman Tom Coles at Chickasaw, in their brief to the Supreme Court during this case, look at the history of the state and tribes cooperating on things, on all kinds of agreements, water settlements, gaming compacts. Of course, that might not be a good example right now with gaming compacts, but in the past, all kinds of compacts, having to do with taxation and water rights and all those kinds of things. They have worked together and have had a very, very fruitful relationship.
You mentioned Congress, and you mentioned the 6 to 8 pages. And my final question to you, Chris. So what does Congress have to do at this point? And 6 to 8 pages, but is there still a lot of work to be done here?
They have to draft it. They have to draft it into what would become a law. Right now you have kind of this agreement in principle that's not written in statutory form. And then everybody's going to have to, all of the parties will obviously have to review that and be satisfied with it. But I talked at length with Congressman Cole this morning, and he believes strongly that if everybody's united on this in Oklahoma, that they should be able to move this pretty quickly. If not as a separate bill, then they should be able to insert it into a bill that definitely has to become law. And that could be almost anything, a spending bill or even a defense bill or something that has to pass, which is what they did in 2016 when they had this really important water agreement that involved Oklahoma City and a couple of the tribes and the state. Jim Inhofe, the senator, put it into an infrastructure bill and got it passed. And Cole stressed that this only concerns Oklahoma. This really has no applicability to any other state, any other Indian tribe, the way anything is conducted in any other state between tribes and state government. It really is Oklahoma specific. So if everybody in Oklahoma is united on the tribe, state government, the Justice Department, if everybody's good to go, he thinks it'll be pretty easy to get through.
Interesting stuff there. As always, Chris Castile, taking something that is massive and making it easily or more easily understood.
Hopefully. Thanks.
His reporting on this, it's on Oklahoman.com right now. We'll have updates as we get them. Chris, as always, thank you for your time. We appreciate it.
Yeah, sure, Dave. Glad to do it. Appreciate it.